Great, I think that's great. Okay. You can put everybody in the BCC though. Right. Then they can't respond automatically. Okay? Because if somebody responds, then yeah, I agree with you. It's in the gray area. Okay. Maybe.
We're on the record.
I gotta be careful.
All right, good evening, ladies and gentlemen. This is a regularly scheduled meeting of the Montclair Planning Board. Notice of this meeting is published in the local paper, and it's also posted in the lobby of this building. We are being broadcast live on Channel 34 and streamed live on montclair.peg.tv. We are holding this meeting in accordance with New Jersey state statute. In this meeting, we will be conducting a quasi-judicial proceeding, meaning that we have powers and procedures resembling a court of law. We are obligated to objectively determine facts and draw conclusions in order to provide the basis for official action that we may take. Any questions or comments should be limited to those issues that the board may legally consider and reaching a decision, and decorum appropriate for a judicial hearing must be maintained at all times. As to the order of this evening, after we dispense with our administrative duties, we will begin to hear an application. The applicant will present witnesses. After each witness's testimony, the board will have the opportunity to question those witnesses, and then the public will have the opportunity, again, to ask questions of those witnesses with respect to what they have testified to so far this evening when the questions have been asked. After the applicant is finished presenting all witnesses and evidence, the public will be allowed the opportunity to comment upon the application, as well as the applicant's attorney will have the opportunity to sum up his presentation. There are a number of things that we need to take care of after the hearing, so we will be watching the time with respect to that. And with that, we'll proceed on to our first order, which is the roll call.
Chair Nguyen.
Here.
Vice Chair Brodock.
Here.
Mr. Schwartz.
Here.
Mr. Cook.
Here.
Councilor Schlager.
Here.
Ms. Willis is excused. Mr. Rooney.
Here.
Mr. Ian Wally is excused. Ms. Lockman. Here. Mr. Barr.
Here.
And Mr. Gilmer.
Here.
Okay.
All right.
That's it.
Next on our minutes, we have approval of minutes. And since there's been some discussion and some issues raised about the minutes, I'd like to shift this to the end of the hearing, of our, our proceeding this evening, because I'm not sure exactly how long it will take us to resolve those issues. And in connection with that also, we have the resolution of the Lackawanna Plaza application, the resolution memorialization, and that too we're not ready to proceed on. We're still receiving comments and working through that. So that brings us to actually down to the fifth item on our agenda, which is the application of HP 37 Orange Road, Montclair, LLC. Long time no see, Council.
Good evening.
What was your name again?
Chairman. So I am Tom Troutner here from the law firm of Chiesa, Shahenian, and Gian Tomasi on behalf of the applicant, HP 37 Orange Road.
Thought you looked familiar.
Mr. Troutner, is your microphone on?
That's what I was just wondering, as I don't hear myself. I'll bring it a little closer.
Thank you.
So, the applicant, HP 37 Orange Road, Montclair LLC, is a joint venture of the Hampshire companies and of Pinnacle. And we are here tonight seeking approval of our application for preliminary and final site plan approval with deviations, and we think a design waiver, and we'll get into that later, for the construction of a mixed-use building to construct 46 dwelling units on 3 floors, above 1 floor of retail, the retail component consisting of about 2,300 square feet. And as you'll hear in testimony, we're additionally proposing the construction of a publicly accessible plaza or public plaza along Orange Road. There is a garage that is being proposed as part of the project to accommodate approximately 67 vehicles on the site, with some remaining parking to be addressed via the Orange Road parking deck located at block 1404, lot 18. The property to which this application pertains is designated on the tax map as block 1404, lots 19 and 20. It's located in the Montclair Center Gateway Phase 1 redevelopment area, and we are seeking, as I mentioned a moment ago, a couple deviations from the redevelopment plan. There is specifically a deviation from section 4.6.2 requiring that there be a lead assessment, guidance, and certification program be utilized to assess a green rating for sustain. I'm sorry.
Is there any way that we're finishing this tonight?
I don't think so. It's hard to...
No,
it's hard
because
to,
I would want to start over if we're gonna, Ms. Willis missed the first.
well, I don't think we have to start over. I mean, I don't think Mr. Troutner certainly hasn't been entering evidence or testimony. He's been just basically explaining what's going on, which we've already seen. A lot of this is already covered in our planner's memo.
Okay.
So I think she got here just in time to avoid a repeat.
They're looking for 3 floors of residential over 1 floor of commercial, and they got a public open plaza. Other than that, Troutner spelled his name right.
Yeah, I think we're good.
So again, there's a couple deviations. There's a deviation from 4.6.2 of the redevelopment plan requiring lead assessment, guidance, and certification programs to be utilized to assess a green rating for sustainability goals. The applicant is going to propose utilizing a alternative assessment program called Green Globes, which is a nationally recognized green rating assessment, guidance, and certification program. Instead of LEED, we'll have testimony regarding that. We're seeking a deviation from section 4.6.3, which requires that at least 50% of the roof surface include solar panels, and an additional 25% of the roof area include green roofs or additional solar panels. The applicant is proposing solar panels for less than 50% of the roof surface, and that obviously doesn't hit the other 25%, although we are proposing green roof. That'll be addressed in testimony. And the basis for the deviation will likewise be addressed in testimony. We are seeking a possible deviation, I say possible, from section 4.7.5 of the redevelopment plan, which requires that parking spaces be designed in accordance with section 281-9 of the Township Code, which states that parking spaces shall be paved with a hard surface paving, which must be connected directly to a paved driveway. The applicant is proposing approximately 58 stacked parking spaces. Stacked parking, we argue, is permitted at the discretion of the planning board, and will be addressed in testimony. We believe that may trigger a design waiver from the township site plan ordinance, not a deviation, but something that can be addressed in testimony. And we are seeking a possible deviation, likewise a deviation from section 4.7.2 of the redevelopment plan, which requires a total of approximately 96 parking spaces. Again, only 67 parking spaces are being provided in the garage as part of this building, which would have potentially a parking variance of approximately 29 parking spaces if deemed necessary to permit those parking spaces to be accommodated in the Orange Road deck. And the redevelopment plan calls for this, so that's why the applicant doesn't necessarily agree it's a deviation, but we can get into that in the testimony. And then lastly,
Could you be specific? What does the redevelopment plan call for?
it encourages the use of the Orange Road deck to accommodate parking in conjunction with applications in the redevelopment area. So that's arguably that's what we're doing. We have parking on site as well as some use of the Orange Road deck. And then one thing to highlight, there were deviations identified in the planning report received from Ms. Talley regarding signage. And she based that on a sample concept drawing of signage that's in the architectural plans. We actually didn't intend for that sample concept drawing to constitute our signage proposal. Rather, what we intend to do is, if this application is approved, to subsequently submit a signage package in the future, and if deviations or variances are required in conjunction with that signage package, they'll be pursued at that time appropriately in the future. But again, it's not part of this application. Now, with respect to the overview for tonight, we propose to present testimony this evening from Mr. Brian Stolar as a representative of the applicant, from testimony from Mr. Stuart Johnson, our architect from Minnow and Wasco, testimony from Mr. Glenn Haydu, who's our sustainability expert. He's also from Minnow and Wasco. And finally, if we get this far, from Kevin Webb from Langen Engineering regarding site civil. And to the extent the board has questions, Mr. Carl Pankey from Langen Engineering, our traffic expert, is also here. And we do, just to sort of lay the roadmap, intend to return to this planning board at a subsequent meeting to provide testimony regarding parking, as well as to provide planning testimony in support of the aforementioned deviations and design waiver that was mentioned, and that would be at the next available meeting. So with that lengthy introduction through, I'd ask permission to have Mr. Stolar come forward.
Before you do that, sir, I'd like to ask you a couple of questions about your introduction. And I see that you left out the planner's point within her memo of 4.1.7.3, multifamily residential office and mixed-use building on Orange Road, effectively where she's claiming from her analysis that the maximum density is only 18 units per acre, and she indicates that you're ignoring that. Isn't it true that you're effectively using a technical drafting a glitch to try and significantly expand the number of units that you're attempting to get into this building? Isn't that correct, sir?
I would disagree with that characterization. So the
I mean, this is what she's written right here. Maximum density 18 units per acre. It says multifamily residential office and mixed-use buildings on Valley Road.
Well, if you just give me a moment, I apologize.
Absolutely.
So Ms. Talley's memo dated March 5th, 2019, quotes section 4.1.7.3. She notes her position is the language in the redevelopment plan as it applies to the subject property she characterizes as ambiguous. She quotes the language which notes that the following requirements apply to new multifamily residential buildings with no commercial components, and then goes on to quote a number of criteria that would apply to multifamily residential buildings with no commercial components. As I believe I mentioned in the introduction, our application concerns a mixed-use building. It has a commercial component in addition to residential. Ms. Talley does note that. The applicant's position is that it doesn't apply. That's correct.
So, Ms. Talley, wasn't that really a drafting error
Yes.
by the either the town attorney or in some communication from your office? And isn't that effectively a ministerial mistake in the labeling of the category? And if that word were in the heading, then effectively they would be limited to 18 units per acre. Wasn't that the intent of the township in editing this redevelopment plan?
Right. The intent is displayed by the title for this section, which is multifamily residential office and mixed-use buildings on Orange Road. As you recall, we went back and there were a lot of changes to the wording in this section of the redevelopment plan, and unfortunately the sentence that followed that heading was never appropriately edited, because it says the following requirements apply to new multifamily residential buildings with no commercial component. the section no commercial component should have come out because we added mixed use as a permitted use into,
So really, this sounds like while the heading of the category is very specific and clear, a ministerial edit issue is what the applicant is attempting to take advantage of here, to put in many more units that the town intended in its drafting. Is that a fair statement?
that's correct.
I mean, I went back and listened to the planning board's meeting on November 27th, 2017, and it was really clear by the end that we were not changing density at all. Density would stay at the maximum, which is 18 units per acre. I mean, that was our position as a board during that hearing. Excuse me.
So
We are
council,
not permitted to increase the density.
I'm sorry?
We are not permitted to increase the density. We're not permitted to exceed the density, because that would require a D, density would be a D5, and that would be the zoning board, and we'd be bereft of jurisdiction.
So effectively, ignoring the ministerial edit issue, both the intent of the board, the intent of the drafting was for 18 units per acre. Should we at this time deal with that now, or let the applicant go through his entire presentation and then rule later?
Well, the other thing is you're trying to make an interpretation, and even with that, interpretation should be made by the zoning board, not by the planning board. When interpretation, you can interpret within the boundaries of planning board jurisdiction. Like if the fence is supposed to be blue or yellow, you can do that. But when it goes to jurisdiction, the zoning board has to do it. There's a specific case on that.
And the zoning board can interpret language in a redevelopment plan?
They're the zoning board, yes, I would say
Okay.
they can, but I think the smarter play for the applicant would be to go seek relief from the governing body. They could correct this within 2 meetings.
That's assuming they wanted to correct it.
Well-
They could, however, just make the edit correction back to where it was supposed to be based on the original drafting. Isn't that correct?
Oh, yeah, I agree.
Shouldn't the governing body really do that, adhere to the intent of the planning board?
No, the planning board, the governing body has the right to do whatever they please. They just have to explain why they're deviating from your sound judgment.
Thank you, sir.
Can someone explain to me where you got your 76, I think it's 72 units per acre? Where did that, is that arbitrary, or where did that come from?
So, well, it's based on the, if you look at the amendments to the other amendments that happened to the redevelopment plan, originally the site would have allowed a 6-story building that could have accommodated more units. One of the changes was that the maximum height was changed for mixed-use buildings along Orange Road to 4 stories. So that brings down the number of units. And then again, consistent with the language in the redevelopment plan, as well as I think the master plan, encouraging activation of the streetscape and the sidewalk of the redevelopment area, or at least our interpretation, or I think it was the township council, or at least I would believe it was the township council's interpretation, that the benefit of having commercial use along the first floor and to activate the sidewalk and the streetscape was a good thing, and therefore they didn't add a density limitation the same way they would have for a building without a commercial component.
So there was no density limitation,
Previously, there was no density limitation at all.
but there was just a floor,
Yeah, but
number of
however,
stories.
because of the constraints of the particular site,
Yeah.
the constraints that are imposed by the redevelopment
Right.
plan, I mean, one could not build a 100 unit
Right.
tower,
Right.
that just can't be done. The 46 units, I don't know if that's literally the maximum number of units, but I can't believe that much more than that could be accomplished and still meet the other requirements of the redevelopment plan. And I'm not, with due respect to Mr. Galvin, I'm not sure that the zoning board can actually interpret the language of the redevelopment
And
plan.
Go back to the governing
Yeah.
body. Right? Normally jurisdiction determinations are made by the zoning.
Yeah.
But if you don't, but in this instance, if you say that the zoning board doesn't have that authority, then it's got to go back to the governing body.
Well, we certainly can look into that. I mean, obviously, I guess I'm concerned. I'm not sure that I've heard before anybody state definitively from the governing body or otherwise that was a drafting error that this should be interpreted any other way.
How did you get?
Well, can I ask a quick question then? So, Mr. Galvin, if a memo on November 28th, 2017 came from Janice to the council saying the planning board recommended that a 4-story commercial or mixed-use building maintaining a maximum density of 18 units per acre and requiring a 15-foot step back at the 4th floor, would the council have had to have, I guess, affirmatively stated why they did not accept the planning board's recommendation in that memo?
When they adopt an ordinance contrary to the master plan or to the regs, they have to do a resolution in addition to the ordinance to clarify their position as to why they didn't follow. If you're just making a recommendation, I don't know that they have, I don't know, I'd have to double check the law on that.
The planning board's recommendation was that with their proposal, it was therefore consistent, with their changes,
Mm-hmm.
it was therefore consistent with the master plan.
Right.
And
So that ordinance.
It's ordinance,
If you said it was consistent with the master plan,
with the additional changes that did not get accurately reflected in the.
Right, with the changes that Ms. Talley wrote in her memo to the council, that was our recommendation as a body, and I believe it was ordinance 017-046 where the governing body approved it, or made their decision and determination on the redevelopment plan.
And we don't really know what the record from the governing body reflects that may impact on this also. Because nobody has had the opportunity to review the record from the council when this was approved.
we shouldn't be supervising the council either. If there's some doubt, we should be sending them back to the council. I always have concern that we're not acting within the time period.
Mhm.
The other thing is we're using the terminology deviation. I have to check that too. That's correct. You're supposed to be saying variances in the parking variance, right?
So what's that?
No variances ever in a redevelopment plan?
Well, no, of course, the redevelopment plan contemplates, actually, it says it in the redevelopment plan, the variance, or deviations that can be addressed by the planning board.
So you're using deviations for variances?
So, hold on a second.
I'm just saying you don't have any variances listed in the one through your notice, you just need to have deviations.
Because they're deviations from the requirements of the redevelopment plan. No deviation from the requirements herein can be cognizable by the Township Planning Board, which is on page 42 of the redevelopment plan. Again, no deviation should be granted that would permit any of the following: a use or principal structure that's not otherwise permitted by the redevelopment plan, or an increase in the maximum permitted height of a principal structure by more than 10 feet or 10%, whatever is less.
Look, my strongest recommendation here is, I think that you should grant this time. I think we should adjourn the hearing. You should go to the governing body and get a clarification. If you're going to force us to act, my recommendation to the board is going to be deny your application. In my opinion, you do not have jurisdiction because you're exceeding the density. And it says 16, it says 18 units per acre, you got 46. Am I missing something?
I think. Well, we have obviously an interpretation dispute, but if I might be granted a courtesy, could I speak to my client just for a moment before we answer that question?
Sure.
Thank you. We take a short break.
Okay. All right, we're going to take a break.
Smoke them if you got them.
agree strongly with the interpretation argument that's been proposed. Reading section 4173, the language is clear. The following requirements apply to new multifamily residential buildings with no commercial component. We also want to note that in September, after our application was filed, the Township Council on its agenda identified an ordinance that it was intending to introduce that would have amended the language of this section, would have changed it to remove the no commercial component limitation. That ordinance, after being discussed by the council, was withdrawn, thereby demonstrating that the Township Council did not want to, intend to, did not change the language of the redevelopment plan. The language of the redevelopment plan.
Objection. I think that only.
You don't have to object, Mark. But let him finish.
Yeah. The language of the redevelopment plan is the same when we applied as it is today. It hasn't been changed. It states what I just read a moment ago. We respectfully would like to request an adjournment of the hearing. We're a little disappointed. We're a little surprised tonight. Obviously, we have a lot of professionals here. We're ready to go. But obviously, there's some things that we'd like to discuss, and we may want to have a conversation with Mr. Galvin and address the issue after an adjournment.
Yeah, I think we need to adjourn this. I don't think this is something that the planning board can deal with this evening until we get some clarification from either the zoning board or the council or the township's attorney. When would we
Mr. Chairman, I'd just
be
like
able
to
to
amend for the record that, based on what the attorney states, that he believes that showed intent of the council. I think it only showed a unwillingness to potentially set themselves up for litigation.
Well,
and that, of course, that's open for interpretation. But I think his point needs to be addressed openly in the public, and so there's my response. That's all I want to say. Thanks.
All right. Clearly,
Excuse me,
it's
as long as you're gonna put that on the
Mr.
record.
Galvin's.
Right.
It's Mr. Galvin's opinion, and it's opinion that's based on information that he's really not privy to. So it only has but so much value, Martin. And I think that's enough that's said about it. Again, this needs to be sorted out outside of this tribunal. So when would we be able to reschedule this, Janice?
Well, I would suggest at this point that we carry this to the April 8th meeting. This is a month. Then
I appreciate the courtesy.
the agenda for the second meeting. The agenda's already full for March 25th. So
Just, I'm also a municipal attorney. If you're going to make a change to the ordinance, you need at least 2 meetings, and then it's got to come here. You might need 2 months to get back on the agenda if they were agreeable with it.
We'll talk after after this.
All right. So this is being adjourned to April 8th. Did you say?
April 8th.
April 8th. All right. And we have all your consents to, if there's any issues with time limitations.
Do you waive the time in which to be heard until April 8th?
Until April 8th, that's correct.
Thank you.
Okay. Thank you.
We need a motion and a second to carry this without notice for that date?
Do we?
That's what I usually do.
Yeah, we don't usually.
You don't do that?
We don't
Okay,
usually
cool.
have
All right,
motions.
cool. I'm good.
Okay. All right. All right. All right, we still have a couple of things to do. And so let's backtrack to the minutes from the January 28th and the February 11th meetings. There's been discussion, issues raised. Carmel, I believe that yours is the most passionate voice.
Well, I don't know if it's passionate. I just feel like, so there's two major sets of minutes. The one being the first one where the public spoke on Lackawanna Plaza. I mean, I guess I felt strongly that the public everybody who spoke should have been, what they said should have been noted in the minutes. A lot of people went to all the meetings. I mean, I don't know what these minutes will be used for. They're easier to read than go back and look at the YouTube thing. So why not? What's the problem with making them more complete? I don't understand.
Well, the problem is that if the minutes are too detailed and are not fully accurate, it can cause problems for us in terms of calling into question our actions. I mean, first of all, since I can remember, and my recall on this board is a couple of decades long, minutes have never been used to memorialize what was said. Minutes were memorialization of the action that was taken by the board. And in general, I think it's accepted, in terms of formal organizations that take minutes. It's generally accepted with few exceptions that minutes are records of action. They're not a transcript, but then there are different kinds of minutes. There's verbatim minutes, there's discussion minutes, and then there's action. There's action minutes.
Right.
Now, if you look at our minutes, our minutes have kind of been there has been a fusion.
There's been a hybrid of both.
There has been a fusion, but if you start recording verbatim in our minutes exactly what is going on and looking to defer to the minutes as opposed to a transcript, that's where people have misunderstandings, because you have, unless it's a fully documented word for word sequentially correct, and that's what the that's
not what I'm trying to do.
The transcript
I'm trying
is.
to in the
But
minutes,
if you're editing what people are saying, and I'm sorry, but you're interrupting me.
Yeah.
So you're editing. If you want to get in and edit what people said, then either you have to take it all down, or else you do a summary of it. I don't think in this particular case, that it serves any purpose to take down verbatim what all of the public had to say about what went on here, and what all of the comments that the board made. I think it's sufficient because we have a transcript that we can get, and we also have a recording. We have a digital recording.
Yeah,
if there's a concern about there not being a record, we can make sure that the digital recording gets preserved with the documents from the application. What I don't want to happen is that something that's in the minutes be used to cause confusion 5 years from now about what went on and what didn't go on. And unless you take down what everybody said, you're going to have that problem. I see, in my opinion.
You're the chair, John. We'll dispute what you want to do.
You know, I think that for the minutes for this meeting, everybody, there were a lot of comments. I think that we should be able to summarize those comments on behalf of the public. There were certain groups of comments that were made, okay? People overlapped in what they said. If we can capture the essence of what they said, and as to each board member if we can capture the essence of what each board member said, I think that creates the record that gives you the tone of the meeting and gives you the sense of how the people were reacting, both on the board and for the public. And then, you know, if it becomes a question of exactly what was said at the meeting, that's what the transcript
I
is
don't
for.
believe my edits were exactly what people said word for word. I understand that there's a transcript. I understand that there's an audio recording. I understand that there's a YouTube video you can watch. What I was trying for is that you have these minutes. They're the first thing that people would pick up and look at to see what happened at this meeting, ourselves included, if we wanted to go back and look at this thing. So what is the problem with making them a little bit more complete so that you get the tenor of the meeting, and you get a lot of what people said? I don't think that
But that's it. I don't think
probably-
we need a lot of what people said.
Well,
I think we need the tenor. I don't have a problem.
I think we need more than was on the original minutes that I looked at.
What are the rest of the board members think?
Yeah.
Sure, why not? I mean, I'm generally a minimalist when it comes to minutes, but that's from my own board, you know, company board experiences. So for me, I'm usually thinner than most, and that's what I've got out of reading Robert's Rules of Order, which is kind of where I caught that bug from, I guess. I don't have an issue adding some things in. I wanted to, like, there were a few things where, you know, I thought there was some hearsay from, you know, the public comment that I didn't want to see in there, because I agree that certain people stated it, but since it was hearsay, I
actually,
really want that reflected
You
in the
didn't
minutes.
change a whole lot of what I wrote for, I think it was the January 28th.
No, I didn't
You
change
didn't,
much.
so I'm surprised at what you're saying, because you didn't really delete a whole lot of what I put in there.
Well, because I don't feel
Yeah.
strongly that I
Yeah.
need to go through and cut out everything. I
Yeah.
mean, I'm just
Okay.
telling you my
Yeah.
approach is
Well,
generally
right.
less.
And that was my thinking, that people can go and they can edit things out. But on the January 28th minutes, I did complete what I thought was a good set of minutes that took for a long time. On the February 11th one, I got an hour and a half, and I said, there's 2 more hours of this. I'm not going to listen to this again. And I had listened to it once before. So I, gave it back to the planner for her staff to do this. And I think that's when we got in the problem. I mean, everybody has different experiences. In my corporate world, we made our minutes very complete, and they were used for litigation, and they were used for preparing people for litigation. So they were very handy from that point of view. So that's my background.
But we have a actual record, a visual.
I understand that,
moment-to-moment
but you could have both. But I'll defer to whatever you want. I just, I don't want to be spending hours on doing this if nobody really wants them that way.
Anybody else?
I take no pleasure in doing these minutes.
I agree they should be action items and high level. It shouldn't be verbatim.
Well, Carmel, I would like to thank you, though, for the diligence of going back through the record. And I think it will serve us well going forward to all be refreshed in many ways, for sure. So I just want to recognize that, like, a lot went into this, and just thank you for that. And I think just like a guiding rule is when someone makes a comment that is, unique, new, incredible, then I think it is good to have it noted. And perhaps there is a way to kind of summarize the bulk of what was in support and the bulk of the dissent, for lack of a better term. But just an example is, stating if someone was in support or not in support. I don't think, those types of details would necessarily need to be in here. But, yeah.
I did want to say, I think certain applications, particularly when there's substantial public interest, potentially warrant more detailed minutes. When there's a lot of heat about a project, that's the time when potentially more detailed commentary about what everybody said could have more of a factor.
And that's why I thought those 2 particular meetings, fit the bill there. One was our deliberations on this 18-month process, and the one before that was the public, who many people sat through 18 months of meetings, and I thought it was only fair to capture what they said, but...
I guess for me, I'm less inclined to write about our discussions, because I feel like, at least for me, I'm... No, well, I wouldn't even say I know what we said. I feel like, I'll say my statement, and then I'll hear a great comment from you, and I'll say, oh, maybe that makes me think a different way. And then so I feel like over the course of our deliberations as a board, I take everybody's comments kind of into consideration, and so I feel like I'm, maybe yes, maybe no, I don't know, so I feel like any statements I make, or they're truthful at the time, but I may change my mind, and I don't know how to capture that in a really good way in minutes, because I feel like we could have a really circuitous path. So I think maybe where I'm coming down to is for the public comment, I think that's fine. I think it's good to capture what people said, outside of the couple of things that I changed. But I think maybe for board members, I'm less desiring to include that in the minutes.
But here's the dilemma, because the minutes are really supposed to capture, again, our actions, and it's the board that's taking the action, it's not the public. A lot of what the public says, while we try and indulge the public and give them the forum to speak, a lot of it is not really relevant and is not really things that we can take into consideration legally in making our decision. So while I'm kind of just the opposite, I think it's more important that we capture what comes out from the board, because just like you're saying that you may hear other people's comments, people may hear your comments, and it may move them one way or the other. And at the end of the day, what really matters is how we voted.
Right.
Yes or no, or not at all. And the whole, again, the whole purpose of meeting is, whole purpose of the minutes rather, is to give us a record and a sense of what was done. And while I don't have a problem with getting the tenor of the public, because again, it was something that the public was very passionate about, and that there were a lot of people here, I don't think that any real purpose is served by saying this person said that, this person said that. I would rather see there were objections from the public as to this, as to that, as to this, as to that, and there was support as to this, as to that, and here's what the board members had to say, and here's who made the motions, and here's what happened with those motions, and that's it. That's the minutes, and then we've got the record that we can make sure it gets preserved outside of the normal channels of preservation. That will go in the files with the it's a disc or two that can go in the file if anybody wants to play it at any point in the future. It won't be something that's hard to hunt down. So if we can, let's try it that way and see if we can compromise it that way.
And so it's actions that we take and points that lead to those decisions as well. So some critical points or issues that are raised, then yes, those would be documented in the minutes.
Right. And then we can, I don't have a problem with expressing what the public felt about it in public comment, but it's comment, it's not evidence. It's not what we're allowed to base our decision on. Yeah. And so to take it down verbatim or in detail, again, it doesn't serve the purpose for our minutes as a board.
And I realize that it was not even verbatim, but for me it did seem like we were treating some of the comments as discussions amongst the board. So even keeping score of how many supported or didn't support,
right,
I don't think that was my only specific point. I don't think that's as relevant to capture from the public.
Right,
comment.
because it's not a popularity contest. It's not
who showed
five
up
on one side and one on the other side.
It's not who showed up that night either.
Right, exactly.
With the board, it is who shows up and votes.
Yes.
But yeah.
All right, so if we can kind of regroup on that. And I don't know whether you want to do any additional, but based on what you've got, Janice, so far, if you can regroup a little bit.
So do you want me to edit the minutes? In light of what you've said?
Right. In light of what, if there's stuff that needs to be added in order to get to what we've just discussed, to get to that tenor business, to get to the expressions from each board member.
And by the minutes, we're saying Carmel's last draft.
Right.
If she can edit Carmel's last
right.
draft.
Drafts, there's 2 sets of minutes.
Right.
With
Well,
perhaps
two sets,
my
right, but I'm
comments.
saying, yeah, January 28th, and then you had more comments on February 11th, right?
I had comments on both of them.
Yeah.
Right, so the latest, but you took in, there's one version of each, right?
I hope
Latest
so. There was
edited
one where I didn't see Carmel's.
No, because that was the January 28th one. It was so sparse that I just started over.
Okay, so I used your file. I
Yes.
just didn't see the red line. So
Yes,
your
right.
comments were in there. So yes,
Right.
if you take my email, unless any of the other board members had comments, that should be the most current version, and incorporating Ms. Lockman's and my comments.
So, okay, so you want me to go and kind of, from what I, condense it a little bit. But what Carmel, because hers was the expanded version?
Right.
Okay.
Right, and if there, of course I haven't gone through everything in detail because of all this discussion that was going on, but insofar as what we have written in it as to the public comment portion, you know, I think we should reflect the full range if we don't have all of that there now. I haven't sat down and re-listened to the tapes. So, and if
But on
that,
that,
Well, I'm confused.
Yeah.
You're talking about the January 28th.
28th one, both Keith and I
that was the
looked at
public, that was
That's
the public,
comment
that was the
date.
public
I know you're
comment.
saying it's complete, but
No,
Well,
no.
what I'm saying is that she added in everything, so you can edit, I think you can edit from that
Right.
to summarize what the tenor of the public reaction
Right.
was at that meeting.
What
And
I
what-
like to do is I like to identify every person who comes up to speak, because my understanding is that we do need to identify the public who comes up to speak
I don't think so.
by name, because we ask their name and their address.
No, I don't think you have to list every single.
I don't think we have to list it
Okay.
in the minutes. We have it
Okay.
on, we have it in the record.
So then
but-
I'll take it back and I'll summarize the statements that were made, okay, for January 28th. Now, the minutes for February 11th, what I did was I summarized the statements from the board members. And,
Not to put myself in hot water, it doesn't matter what you say at the hearing. It does, it's very, very important, but the resolution is the final destination
Right.
of your opinion.
Right, so that's why, again, that's why in just trying to get a summary of what was discussed,
right,
things that we considered, and then the resolution shows how we finally voted.
And-
The courts have been known, even when there's a 5-something vote, to say Councilman X or Commissioner X said something, but that doesn't necessarily express the opinion of the entire board.
Right.
Sure. Right.
And that they feel, but I usually encourage my board members, and you guys did a great job of all expressing
Right.
your opinions. So I felt that I used it in the crafting of the resolution,
Mhm.
and I feel I could defense it when we go, if I had to go to court, which I see is unlikely.
So far.
Okay. There's gotta be a predator out there, competitor, but you know.
Yeah. All right. So
Okay.
are you good, Janice?
yes, I'm good.
Okay, and let's see where we go from there.
Okay, thank you.
It's not unanimous approval of minutes. I'm not happy. I can still vote
That's
no.
right.
Yeah.
Yeah, yeah.
It's not necessary minutes if everybody's addressing.
I didn't.
No.
hear what
Put
you-
their addresses in.
No.
I notice it's all, every address is, everybody wants to.
I just, because when, I think I put it in the minutes, I put it in my notes, because when a person's making a comment, I think it's important to know where their comment's coming from, where they live.
As a matter of their being right, the court's very wide on being able to speak, but you have to have the right to speak. So if somebody was coming here from Wildwood to comment on this case, you wanna know.
From Washington?
Yeah.
Oh, right.
I
What
don't
happened
know,
you?
I don't know at what point we can't preclude it, but, I think the concept of that, you put down the street address to show that they have the right to be a party in the action that's a comment.
Right, but I don't think we need to reflect the addresses in the minutes.
I
We have
think-
them, we have them in the record.
Sorry.
I think in the record, I'm just looking at the minutes to see
Right.
everybody's addresses.
Right. Of course,
And
if
you were
we-
saying you
if we-
didn't feel like it's necessary,
Yeah,
right,
so I'm
Carol?
saying
You're
some
saying
people
it's,
it's necessary.
yeah,
Right.
right.
If we don't need the names, we certainly don't need the addresses.
Okay.
Oh, so we're not
Good
doing
point.
names? So if we're not doing names, but if we're doing names, I think you might want to say Mr. Scott of the whatever.
Or
know,
you could say of so-and-so street or this
No,
or
no,
that or the
no,
other.
of the NAACP or the.
Yes. Oh, yeah, well, that's-
So that was missing
that's-
as well.
That's
Yes, yeah, I
that's
think that's
titles
important
and
that you.
organizational
that's-
affiliations, yes.
Yeah.
Yes.
Mhm.
Yes.
Take that out, but his affiliation. Be people who have an affiliation, that should be noted.
Okay, so you'll give it a shot, and then we'll send it back out and see if we can work with that.
Okay.
Do we have any committee reports?
Oh, you know what? Carol, I'm trying to schedule a meeting of the zoning subcommittee. I haven't heard about, after tonight's meeting, maybe you can tell me what days you're available? Okay. So, and that's because I'm working on amendments to the zoning ordinance in a piecemeal approach. I think, rather than, I think the huge rewrite of the zoning ordinance was too broad. So now we're trying to prioritize some of the things and get that to the council so some of the changes can be made. And that's kind of what I want to speak to the zoning subcommittee about first before I go to the EDC, and then we go to the council.
And we do have a new member on the board who's taking over, what committee?
For Craig, he was
for
only
Craig.
on the nominating.
He's only on the nominating committee. So, if you wish to participate in some of the other committees, we'll see what we can do to make that happen. You don't have to decide this evening. And, you know, hopefully, like I said, we'll, over the next couple of weeks, we'll have a chance to chat and get you a little bit more oriented, and then can figure out what you have time for and what you have interest in. Okay.
And that's
And do we have bills?
We have bills.
Do we have bills that are acceptable?
Bills. I would
Were
accept
your-
the bills.
All of your questions have been answered?
Yes, they have. I would move to accept the bills.
okay.
And I'll second.
All in favor?
Aye.
Opposed? Abstentions? Approved. Okay.
All right. All right, we get to go home early, everyone. Thank you.
Wow, Oracle.